A very good afternoon, everyone. Thank you so much for joining us at this CGM AIAC Malaysia Bar webinar series on international investment agreements and investor-state dispute settlement. We are in our first session in conversation with Mr. Toby Landau KC on IIAs and ISDS, misalignment with Paris Agreement goals, depoliticization and system transformation. And I'm very excited to be introducing the panelists who will be giving various comments throughout this session. We first have Ms. Kwong Chiew, who is representing the Malaysia Bar Council, to be providing introductory remarks. Then we have Dato Mary Lim from the Director of the Asian International Arbitration Center, who will be providing her wisdom in a keynote. And then we will have a conversation with Mr. Toby Landau KC, barrister advocate from Duxton Hill Chambers. And then after that, a short discussion, a panel discussion, and then we have a time for audience Q&A as well. So without further ado, let me just turn over to Chiew to provide introductory remarks for this session.
Thank you, Elizabeth. A very good day to our distinguished guests and participants. On behalf of the Malaysian Bar, it is my pleasure to welcome all of you to the first session of the three-webinar series titled Synergizing Foreign Investor and State Climate and Environmental Priorities. Now, this forum, I believe, comes at an important moment. Around the world, we see an emerging tension between deregulatory trends in some countries and increasingly ambitious climate measures in others. And against this backdrop, the international investment regime, and especially investor-state dispute settlement, or ISDS, is facing growing scrutiny. The central question in this moment is whether international investment agreements, IIAs and ISDS, enable or inhibit states in pursuing their climate and environmental objectives under the Paris Agreement. Our discussion today goes directly to the heart of this question. So in setting the scene, it is worth recalling the insights of Professor Kaila Tianhara, who in her seminal work back in 2011, Regulatory Chill and the Threat of Arbitration, a view from political science, warned us that the mere possibility of investment claims can deter states from enacting robust environmental or climate regulation. This concept of regulatory chill has since taken center stage. It captures the broader dilemma that we all face. How does a state ensure that investors' rights or foreign investors' rights are preserved while also safeguarding its own sovereign rights? And if I may go one step further, its own obligation to take decisive climate action. So reforming the current IIAs and ISDS regime is therefore not only about avoiding the chilling of legitimate regulation, but also reimagining it as a mechanism that can enable rather than obstruct the green transition. So to illustrate the human impact of investor-state dispute settlement, I would actually like to recommend the audience to watch the 2023 documentary film, The Tribunal, by Malcolm Roach, produced with the Columbia Center on Sustainable Development. The documentary tells a powerful story of the residents of Intact Valley in Ecuador, who oppose mining operations by the Copper Mesa Mining Corporation, one of the largest mining corporations in the world, and later found that their own state was sued before the Permanent Court of Arbitration for breach of an investment state agreement. This documentary film, exposes the asymmetry of the ISDS system, how it affected local communities, and how local communities are excluded from the proceedings, although the conduct of the foreign investor profoundly shape and affect their lives. So the maker of the documentary describes ISDS as a system that has increasingly come under the scrutiny of policymakers and civil society. We must remember that IIAs and ISDS are relatively modern constructs. They are barely 6 decades old. They can trace their origin to the post-war and decolonization era, when newly independent states were asserting their sovereignty and former colonial powers sought mechanisms to safeguard their investments in their former colonies. So the establishment of the Exit Convention in 1966 institutionalized the system. And by the 1970s, the ISDS clause became a standard in investment treaties between developed and developing countries. Over time, the system then expanded through multilateral agreements such as NAFTA, TPP, RCEP, all of which have incorporated one form or another ISDS provisions. Yet, as the Documentary Tribunal noted, as well as most recent reports by the UN Special Rapporteur on Human Rights and the Environment, the ISDS system and IIAs can have devastating consequences for human rights and vulnerable communities. Very few investment treaties even mention the right to a clean, healthy, and sustainable environment, despite the fact that such rights have been recognized as fundamental rights by many human rights treaties. So critics also note that ISDS have, in some cases, constrained states' regulatory space. So as the global landscape shifts towards sustainability and human rights-based governance, the traditional ISDS framework has to be reconsidered. The interplay between investment treaties, environmental stewardship, and social equity presents both challenges and opportunities for reform. Encouragingly, these ideas are beginning to find expression in institutional reform, primarily through the works of the UNCITRAL Working Group 3 on ISDS reform that has recognized that regulatory chill has become a core concern in international investment law, affirming that states should have a right to regulate, and that tribunal should afford a high level of deference to public interest measures, including perhaps carving out ISDS claims aimed at protecting public health, safety, or the environment. So as ASEAN leaders meet this week to chart our collective future, the timing of this forum could not be more fitting. There is to be had an important regional conversation about new models of dispute resolution and new models of IAAs, perhaps. The traditional ISDS framework emerged largely from global North economic paradigm, designed in an era where capital flowed primarily from developed to developing countries. For the global South, including ASEAN member states, a regional approach offers an opportunity to rebalance this system. From the Malaysian bar perspective, lawyers have an indispensable role to play in addressing these challenges. We must not confine ourselves to applying existing treaties as they stand, but take on a more formative role in designing and interpreting legal frameworks that protect investment while at the same time advance public interest in climate action. So this also means that we need to look at increasing domestic capacity, strengthening institutions like AIAC and our national courts if we want disputes involving environmental or public interest dimensions to be resolved in a way that reflect our national policy priorities and our constitutional values. The Malaysian Bar's support of this webinar series is part of its broader commitment to advancing informed interdisciplinary dialogue on how law can serve the public interest in the age of climate change. As practitioners, scholars, and policymakers, our role is to ensure that the international legal system evolves to reflect the urgency and equity of the climate transition. So finally, I would like to take this opportunity to congratulate Climate Governance Malaysia for organizing this important series in partnership with Malaysian Bar and the AIAC. It is through forums like this that allow us to bring these global conversations on climate and international investment back to Malaysia and to consider how international principles can inform and strengthen our domestic legal policy and institutional framework. With that, I wish everyone an engaging and thought-provoking discussion ahead. Thank you, and I will hand over the floor next back to Elizabeth to begin the next session.
Thank you so much for that, Chiew. I will now invite Dato Mary to give a keynote, please. Dato Mary, you have the floor.
Thank you very much, Elizabeth. Actually, it's not a keynote. I'm invited to just make opening remarks. Distinguished speakers and participants, having just heard Chiew made those observations, she actually has set the scene quite well. She has quite clearly sent a clarion call out. It's a regulatory chill. And thankfully, the Working Group 3 at UNCITRAL has been very much at work and doing much that all of us should be scanning our attention to. And with those early observations, let me just immediately say that on behalf of the ASEAN International Arbitration Center, which is the AIAC, I must surely offer my congratulations and also most sincere appreciation to the Climate Governance of Malaysia, the CGM. And I want to single out Dr. Gary Thasera, also you, Elizabeth, and so many more of your cohorts for this opportunity to collaborate at the close of the first quarter of the 21st century on what I see is a moment to redefine and to realign not just our approach on ISDS, but perhaps to the whole business of how we live our lives, and in relation also to dispute resolution. This opportunity to collaborate is extremely heartwarming. I've always believed in working together instead of working in silos, and Chiew's reminders of how institutions as well as the judiciary should join in this effort is very, very important and timely. And we should not be in competition on a matter such as this. And in fact, we should not be repeating what others are doing, but be collaborating. So I'm indeed very proud, personally, as well as on behalf of the AIC, to be a supporting organization for the webinar series. I understand today is the first of the three-part webinar series focusing on ISDS. And today's theme, as explained by Chiew a moment ago, is about synergizing foreign investor and state climate and environmental priorities. And it's so thankful to like-minded groups of CGM and leaders like those who will be speaking today, who continue to challenge and to remind all of us that there really is a correlation between investor agreements or IAs and investor-state dispute settlements, ISDS, because our climate and our environment, our initiatives and responses may actually be undermining instead of protecting our environment and our climate. And if we ever were to just glance at the ISDS statistics, you will see, I understand some 26% of the cases that have taken place actually concern oil, gas, and mining, while another 15% of the disputes relate to electrical power, to solar power, and other energy resources, which are so important to our life and to the maintenance of anything of meaningful existence. And then there are the cases on public health, which Chiew also alluded to. So indeed, it's timely that discussion takes place, as we cannot ethically practice ADR of any meaningful degree, let alone have any future for the human species to survive. An arbitral institution such as the AIAC cannot and must not any longer put our hands up in despair, or worse, stick our head into the sand and say, well, this is somebody else's problem, it's not ours. We need to be aware, we need to make choices, and we need to take action. We must rise, as Chiew has mentioned. So I'm indeed looking forward to the conversation that Elizabeth will have with Toby on this important question of whether IAs and ISDS are at all misaligned with the goals so well set out under the Paris Agreement, and perhaps even suggest that or advocate that there should be some depoliticization and system transformation of all these international arrangements. Chiew made reference to the fact that it's timely because the ASEAN summit has been taken place and quite a lot of other distracting stories that have come out from the summit. But I am reminded that in August of this year was the ASEAN Law Forum. We had at the AIAC had a huge part to play with that. But one good thing that came out of that forum is the law ministers of ASEAN taking an initiative of issuing a joint statement on the development of a framework for international commercial arbitration, as well as mediation framework in ASEAN. Perhaps the outcomes of today and whatever will be taking place in the next two parts could be taken and escalated to the ASEAN Secretariat for consideration and inclusion, so that, again, I go back to what I say, we should not be working in silos or in competition or doing repetitive work, but be collaborating for the better good. So I want to end by thanking all the experts and the enthusiasts for giving up time. Thank you, Toby, for allowing yourself to be part of this rapid fire. I think that's going to come from Elizabeth. I'm sure you're going to enjoy yourself with these very clever ladies who are so dedicated to the cause. Thank you so much. And thank you very much for giving me this honor and this pleasure. Congratulations.
Thank you so much, Dato Mary, for those extremely kind remarks. And indeed, it's such an honor and pleasure to be collaborating, and hopefully the fruits of this particular conversation will, as you say, inform further discussions in ASEAN and to incentivize particular efforts to look at areas of the system which can be helpful in addressing these problems. So now moving to the conversation with Toby. So Toby, first, thank you so much for joining us. I think a number of the audience members have a couple of questions already for you. I'm just going to start off by getting your reflections on the core mismatch, which Chiew alluded to, that is potentially inherent in the ISDS system with climate and environmental governance. And you had a really insightful and I think galvanizing lecture to the 2023 Alexander Lecture, in which you described this mismatch. Could you perhaps explain to us what is the nature of this mismatch and the urgency of addressing this in light of the triple planetary crisis?
Absolutely. I just begin by saying it's a great pleasure to be part of this webinar and part of this series. And I congratulate Climate Governance Malaysia on the very inspiring work that they're doing at the moment, which is much needed and very timely. The mismatch, I think, has already been well articulated in the introductory remarks, excuse me, between the investor-state regime and the Paris Agreement targets and the initiatives generally in terms of climate nowadays. But I'll summarize where I see the problem is. If we sketch how we got to our current position in investor-state protection, it goes back to 1959 and the Germany-Pakistan First Bilateral Investment Treaty. As we all know, that gave birth to a web of international treaties, now approaching around about 3,000 treaties, possibly 2,600 at the last count. That is a network of regulation, of guarantees for foreign investment that was put together and developed at a time really long before climate was an issue. So climate change and Paris Agreement goals and the pressures that's put upon everyone were simply not contemplated when that structure was put together. The result is that we have a core area of activity in investor-state arbitration that is relatively politically uncharged and uncontroversial. Excuse me. But now increasingly, this system is being used for disputes that are arising out of the climate context. And that is a field that is fast, or an area of disputes that is fast expanding. It's pushing the limits of the coverage of treaty protection beyond what would have originally been contemplated. It's focusing upon an ever-increasing range of sovereign acts, again, that may not have been contemplated previously, and it's pushing the breadth of treaty guarantees. Now, what that means is that we are now facing a large number, increasing number of claims by foreign investors against host countries on the basis of damage that they perceive to their investment by reason of the implementation of climate policy. And actually, those are concrete claims, and one can see them increasing, and one can see them increasingly reported. I've seen, I mean, a startling number of new claims, and that is wherever, for example, a state wants to curtail, for example, fossil fuels. A fossil fuel investor will have naturally a claim that there's been damage done to its investment. The mismatch actually lies at the nature of these disputes compared to the procedure that we use to resolve them in investor-state arbitration. So very, very briefly, investor-state arbitration has adopted the commercial arbitration procedural model. That is a procedural model that was founded upon old-fashioned contractual disputes. Contractual disputes are horizontal in nature. That is, even if a state is involved, they are between two parties who have formed a process between them to resolve disputes between them with a view to affecting nobody else. But investor-state disputes, and in particular climate disputes, are vertical in nature. That means they're much more like public law. An investor can claim against a sovereign with respect to sovereign policy that will have effects way beyond the immediate parties. Effects which will go to policy that could be regional, and indeed, when we talk about climate, they could be increasingly global. And so what we're doing is we're squeezing a different kind of dispute into a procedural model that wasn't designed for it and actually is ill-fitting for it. And that gives rise to a lot of internal tensions and pressures, and it undermines the legitimacy and actually the robust nature generally of these determinations, because we're actually leading towards or allowing for determinations in investor-state dispute resolution that are not sufficiently accountable, do not sufficiently take into account all stakeholders, do not sufficiently place the decision makers in a position where they can actually assess all factors that may be relevant. And I think if you know what I've articulated previously, I think still holds at the moment, which is there are really three core problems with this mismatch. The first one is a lack of access of stakeholders. Climate will affect all sorts of stakeholders way beyond the immediate disputing parties. Those stakeholders will not have a say generally in investor-state dispute resolution because they're not party to the actual dispute. And although we allow for limited mechanisms for intervention, such as amicus curiae or other kinds of interveners, that is a half-hearted concession to non-parties. It normally is not taken so seriously by tribunals. There are concerns that it may exacerbate the scope of the dispute, may impose costs on one side. And so actually, it's a very limited opening for outsiders to come in. And that means that there is less information provided to the tribunal to actually resolve these disputes. Secondly, critically, the problem of process leads to what I've called previously arbitral tunnel vision. And that is arbitrators won't look beyond the immediate arguments that are being put to them. So they are completely reliant upon whatever the state may argue and whatever the investor may argue. The investor increasingly has got no interest in bringing wider climate issues. The state may have an interest but not the ability or be sufficiently agile and able and resourced to do so. And so the result is that decisions are based upon limited, imperfect records. And lastly, we've got the problem of polarization. The adversarial procedural model forces parties to be polarized. That means the tribunal gets extreme views and doesn't have the middle ground accounted for where policy is actually made. And therefore things are black and white when in fact they probably in reality are gray. So the result of all of that is an imperfect process that's under huge strain. It's ill-fitting. And of course, we are thereby ending up with the danger of decisions which will impede climate policy and actually will have a chilling effect.
Thank you so much for that, Toby. I think there's so much that you have said that I think would be great to unpack. And for those listening, if you want to understand in greater detail, please refer to Toby's Alexander lecture, which is online, where he goes through that whole range of issues in detail. But now I just want to turn to, I think, some recent new developments. And just this past July, the International Court of Justice has issued a historic opinion on the obligations of states in relation in respect of climate change. So may I ask, how do you see these developments in public international law influencing ISDS arbitral tribunals? And perhaps relatedly, as an arbitrator, what is your responsibility when faced with, say, a treaty which seems to conflict with certain types of public international law developments on climate or human rights?
Well, it's a very, very important point that you've raised. I think that these recent developments in jurisprudence, and in particular the ICJ's advisory opinion, are extremely significant. They've got huge potential to change the course of decision-making in investor-state dispute settlement. What the ICJ in particular has now made clear is that states have clear legal duties under international law to prevent significant harm to the climate system, as well as protecting human rights from the impacts of climate change. So states can, in theory, be held legally accountable for greenhouse gas emissions. In particular, they can be held legally accountable for attaining the Paris goals. But the question now is how that will actually filter into our system, since it's an advisory opinion, it's not legally binding as such. I think what is very, very important is that the ICJ has now clarified that there are climate obligations that derive not only from climate treaties, but from broader customary international law. And in particular, for example, duties to prevent transboundary harm. And what that means is that we now have the tools to allow us to do something that some of us have been asking for, campaigning for a long time, which is an active role by tribunals towards systemic treaty interpretation, and in particular under Article 31.3c of the Vienna Convention on the Law of Treaties, because now we do actually have legal principles which can inform treaty interpretation. So even with old style bilateral investment treaties, older generation treaties with broad textured guarantees, there is now a route through conventional treaty interpretation and customary international law to calibrate obligations such as fair and equitable treatment, legitimate expectations, arbitrariness, non-discrimination, by reference to what are states' obligations. So that means that arbitrators now can actually say, if I'm going to look at what is a legitimate expectation of an investor, for example, a coal investor, a fossil fuel investor, I can match that with what actually is the counterpart, and that is a state with legal obligations to reduce fossil fuel usage. And that now gives rise to an analysis that I think was harder before, without concrete sort of milestones. We now have a structure. So I'm optimistic. But going to the second part of your question, what this depends upon in a world which does not have precedent, which is run by ad hoc decisions by ad hoc panels who are appointed and then no longer have any status. And with all the stresses of the process that I've outlined already, this really turns still upon whether arbitrators will stand up to the moment and actually do as they can do. There's nothing forcing them to do it. And that requires mindset change. It requires a wider vision and a sense of global responsibility.
Thank you so much for that, Toby. Just picking up on your point with respect to ad hoc tribunals. So with the Intra Working Group 3, there is a push for a multilateral investment court as a central part of the reform package. And you've also spoken about the need to depoliticize the system. Do you think a standing court is potentially one of the answers? And do you also have further thoughts perhaps on more systemic reform of treaties or other elements such as draft guidelines on damages or other types of innovations that might assist?
Well, I do. And I think that the standing court idea is an excellent one. I say that knowing that it is incredibly difficult it will be to achieve. It is very ambitious. There are any number of reasons why it won't happen or can't happen. but in my view, it really should happen. And I think that we have the ability as an international community to do it. We have done similar things previously, keeping it apolitical, keeping it legitimate, accountable, inclusive is extremely complicated. But as a goal, I think it is very, very important because it actually solves this problem of the ad hoc tribunals that are not linked up, that come and go, and it would be the beginning of some stable jurisprudence where principles can be taken into account and dealt with uniformly, or at least near uniformly, across these kinds of disputes. And we simply don't have that system at the moment. I mean, I can tell you as counsel in investor-state dispute settlement, it's virtually impossible to give any substantive advice to clients. All you can say is that there is this line of jurisprudence, but it may or may not apply depending on the tribunal. And that is increasingly unacceptable in something as critical as climate change. So in terms of the work of the UNCITRAL Working Group 3, the work is to be commended. It is long-term, it's not easy, but it's actually contained within really our existing system. Apart from the idea of a standing court, you'll be aware that most of the work is actually improving what we have at the moment. So with respect to, for example, the advisory center, with respect to codes of conduct, with respect to what they're calling cross-cutting issues, third-party funding, efficiency, and those sorts of things. And that's to be applauded, and it's necessary. My own feeling is it's just simply not enough, because the Working Group 3 work, and I don't mean to denigrate it at all, because it's probably more realistic than what is in my dream world. But what it's doing is trying to uphold a system which, to my mind, is still fundamentally ill-suited. And actually what we need to do when I talk about depoliticization, what we need to do is to stand back and think of a system that would actually go to the core of these disputes to deal with the problems that we currently have by virtue of the process. That is, a system that places a tribunal in a more complete situation in terms of information, input from stakeholders, understanding competing norms, not being restricted to whatever happens to have been argued in front of it. And that actually militates against a strict contractual style adversarial arbitration system. It actually militates much more towards something that is more of a commission of inquiry, where a tribunal is able to take soundings and consult and take the initiative itself to resolve an issue by thinking of all different matters, all different stakeholders, in order to arrive at a robust and fair result. And that's much, much more ambitious. Repoliticization is although it's counterintuitive, is the idea that really we don't just think of disputes in terms of a divorce from their social and economic genesis by virtue looking at legal principle. We actually put them back in the setting that generated the dispute in order to consult more broadly, in order to take into account all the issues and dynamics that exist in that world and come to a result that caters for all of that.
Thank you so much for that, Toby. I think, in the absence potentially of a commission of inquiry type model for tribunals at the moment, do you think then counsel should potentially be doing something different, perhaps? What are some considerations maybe when a counsel advances a claim that could undermine environmental and climate protection? Is that even a relevant inquiry?
I think it absolutely is, but I'm just going to broaden the question slightly because I think the obligation is on tribunals as well as counsel. And now we really have to think a little bit more laterally than perhaps we never have before. So in traditional practice, an arbitrator is simply concerned with resolving the immediate dispute before him or her, and listens carefully to the arguments, whatever the arguments are presented, and comes to a conclusion. And counsel's role traditionally has been simply to advance the interests of their client, whether it's state or investor, and you don't think about anything broader. And of course, all of that is absolutely acceptable and established. But now we're in a different world. We're in a world of climate crisis. So we've actually got to wake up to what we are doing and its potential impact. the process of investor-state dispute settlement undoubtedly has a major role to play in climate policy and climate control. So to actually, with that on board, we actually have a broader moral duty, whether we're arbitrator or counsel, to conduct our process in a way that furthers the interests of climate control and resolving this crisis rather than deepening it. So for an arbitrator, I see that as a duty to look beyond the immediate dispute at the overall lasting impact of the decision within the bounds of what is acceptable within jurisdiction, not breaching natural justice, not breaching a mandate. And I also happen to think that counsel increasingly must see their role against the greater good, not just the individual client. And if you allow me just 1 minute on this,
Yes, of course.
if you think about international rule of law, international rule of law is under pressure at the moment. We are in a world where there are various governments that are now pulling away from a concept of international rule of law towards national self-interest. And that's putting pressure on our international system and the post-World War II system or world settlement that we had all taken for granted. What we've got uniquely in our field of international dispute resolution is our own transnational rule of law, which operates apart from governments. We're not subject to government national policy. We work across borders. We've created an amazing system of international dispute resolution, which is transnational. It certainly supports and forms part of international rule of law. And I now feel that we have an obligation to sustain that because of the breakdown of international rule of law. If we can't count on governments and countries at the moment to collaborate, we must carry on our collaboration and what we're doing in our transnational system. And I think that feeds straight into the duty of counsel when they're actually running cases to run them with that broader view. And it's not to undermine their clients' interests by any means. It's not to act against their clients' interests. Of course, they can't. But it is to have a broader vision. And that broader vision would be in a dispute to consider what the impact is of what they're arguing, to formulate their arguments in a way that is consistent with what are now increasingly international norms or at least in international requirements. And that's asking a lot because it's a change in mindset, not only of arbitrators, but of counsel also.
Thanks so much, Toby. If I could just maybe go slightly off script and just pick up on the point that you just said, are you then potentially suggesting some form of soft law coalescing of guiding principles that it could be initiated potentially by one of the international arbitration-related governing bodies beyond, of course, the already guidelines and principles that are in place? Do you see this as some form of transnational governance that you have just suggested, but just trying to make it sort of practical in terms of how operationally that would look like?
I think that's one way into it. Changing mindset is one of the hardest things. I mean, historically, it's incredibly hard, and you can't legislate for mindsets, and you can't rule make for mindsets. But what you can do is to increase a sort of direction of travel that people perceive as something as acceptable, and that the more people do it, and people see their peers taking on these broader issues, the easier it is to start to change mindsets. So transnational principles, maybe soft law, maybe or soft rules, maybe one way towards this. It's difficult to find other ways towards it other than simply persuading people by events such as this. But I think that but the idea of starting to think about international codes of conduct that take into account a broader context, we've not done that before, and I think actually it's something that we now need to do.
Thank you so much for that, Toby. So now just opening, I think, to audience and to the panel. So I'm going to bring Chiew into this discussion as well. And audience, please, if you have any questions, do continue to keep them coming. So just to get a perspective, perhaps, on from the perspective of the Malaysian bar, Chiew, what role do you see lawyers playing, I think, in addressing the problem that Toby has provided several different perspectives on? Maybe it's a lot to potentially ask because there's so many facets to this issue. But just keen to, I think, maybe hear some reflections and then just toggle between you and Toby on this.
Yep. So I don't think I can do any better than what Toby has said. So I think lawyers, we have an important role to play to ensure that the international investment law system is used fairly, not to fuel opportunistic litigation. So one example I can use, and I think most Malaysians is aware of this case, the Sulu arbitration. So it's a stark reminder of how in certain cases, international arbitration mechanism can be misused, where speculative claims that threaten national sovereignty and public resources can be mounted against states, particularly states in global south. So lawyers must not be complicit in encouraging these types of disputes. So our responsibility is to uphold the rule of law and also the integrity of the legal system, which would include the ISDS system, and not to exploit the system. So this, of course, means that we must give sound and balanced advice to our clients, whether we are representing foreign investors or states. We must ensure that our interpretation of investment treaties and investment contracts are aligned with public policy objectives, particularly the objectives of ensuring that conduct of foreign investors are not contrary to the climate objectives of the states that they are operating in. And as to quote Toby, that we carry a moral duty. We must integrate environmental and social responsibility into our practice of law, and in doing so, hopefully reflect the duty to ensure that in whatever that we do, we consider sustainability as an agenda that is paramount in our legal practice.
Thank you so much for that, Chiew. So I'm just going to go to a question that came in for Toby. Can you share perhaps some reflections on your journey in this space? What made you come to the present views that you now hold?
So I'm now I'm going to be very careful by not naming names, but I have to say that I had an increasing concern. I've had an increasing concern sitting as arbitrator in investor state cases. I split my time, so mostly as counsel, but a lot of time as arbitrator as well. And as counsel, you don't really see these points because you get very absorbed in the case that you have to advance, and you do everything you can to win for your client. When you're arbitrator, you're then faced with, in this field, increasingly significant issues that you have to determine. And I had an increasing worry that I wasn't hearing everything that I needed to hear in these cases when they were involving climate issues. And the more profound concern that I had, and I still have, is the lack of sympathy for that amongst my colleagues. There are a world of arbitrators out there, I'm afraid, in this field. Of course, it's a small field. It's quite a closed field in terms of participants. But there's a collective mindset that, in my view, is now simply outdated. It's really a limited sort of contractual mindset, actually, of arbitrators who will not see the bigger picture. All they're concerned about is being fast and efficient in the dispute resolution, and not breaching natural justice by going beyond whatever is being argued in front of them, so that when, in many of these cases, third parties start to line up and ask whether they can intervene, there's a very, very significant reluctance on the part of the majority of arbitrators, I'd say, to allow that to happen, because that doesn't happen in contract arbitration. It's alien to most people's conception of what this dispute resolution process is, and they're simply not seeing this in the wider context now of what I think is just a new world, actually. So that's what's driven me. And as I often say, the day after I retire, I'll publish the names.
Well, thank you, Toby. I hesitate to say I'll wait for that because I think it would be a great loss if you do retire. But in any event, I think and I'm mindful also that we've had such a wonderful discussion and we are kind of about to wrap up. I just want to have two questions that I leave with Toby and Chiew. I think the first is from a sort of very individual level. For lawyers, what is the most effective and practical advice you have for practicing lawyers, junior or senior, on how they can support the system's transformation. That's one. And then my second question, which is perhaps a little bit too big, but I'm going to try anyway, is on a country level, are there specific substantive reforms? If you could just maybe give one example, because there could be so many, right? That to refer to investor protection. Is there something that maybe treaty negotiators or countries should be thinking at in a very focused manner? So perhaps I will start with Chiew and then go to Toby to close the session.
Yeah. So for the first question, I read in the Straits Times a couple of days ago about how Singapore needs to train a new generation of lawyers that are well-versed in international law. And I think I echo that in the context of Malaysia and regionally as well. We need to cultivate a new generation of ISDS lawyers and arbitrators from Asia who can advise and represent both states and investors from the region. So at present, I think the ISDS field is still very concentrated among a relatively small group of practitioners, mostly from the global north. Of course, there are exceptions like Toby. He practices extensively in both global north and south. But I think expanding the regional expertise in Asia is quite important to ensure that the voices and experience of the global south is represented. So that's the first question. The second question, I have a couple of ideas in mind, but I'm not part of the
maybe just one, because we
just
need
one.
to wrap up.
Yeah,
and
so,
I saw another question come in from
yeah.
So
this interesting concept of horizontal obligation on how you should impose BHR, business and human rights obligation, downwards on investors instead of from state to state. So perhaps you could consider reforming the international investments agreements to impose direct obligations on foreign investors to ensure that they meet human rights and environmental standards. It is quite radical, and I don't think I will see it in my lifetime, but it's an idea.
Thank you so much. And Toby?
Well, these are very, very important and big questions, which we have insufficient time for, I'm afraid. But on the first question, I echo very much what
we have a bit more time. I'm just going to push everyone in this webinar. So let's maybe have a little bit, 5 more minutes, if that's okay. And
sure.
Yeah, just take your time. Thank you.
All right, thank you. I think on the first question, I completely agree with what Chiew has said. The world of international arbitration is notoriously a small world and difficult to get into. It's often referred to as a mafia, mutual association for international arbitration. The ISDS is even smaller. It's a subset of that. And that's for historical reasons. It's grown up in that way. It is expanding. It needs to expand much, much more. And I completely echo the thought that what we desperately need are young practitioners who are well versed in international law and these kinds of climate issues. And those are the ones who will be the future. And they are the ones, because I think mindsets are so difficult to change. If you can't change your mindset, what you need is new minds. And the new minds are there are openings for new people, and people should, I think, strive for this, and they should educate themselves as much as possible, and I think they should speak out. And I call upon people in the field also to speak out, because there are few of us who do speak out in this way, because a lot of people are so concerned with just securing their next appointment or their career trajectory. I tell people very often that my speeches are designed to be career shortening, because actually, in the end, unless you say something radical which shakes people up, people don't listen. But actually, these are radical thoughts. They do involve people being shaken up, and I think people have got to have courage to do that for our collective good. So that's what I would encourage practitioners to do: is to get as well informed as possible and be as outspoken and be ambitious and try and break into this field and start advising, whether it's pro bono or whatever, in order to get onto the radar and become people who are sufficiently credible to be appointed as arbitrators, maybe beginning as tribunal secretaries and as counsel. And I think in terms of the second question, that is very, very difficult because, aspirationally, we would say that, of course, countries should just modify their treaties. What they should do is have new generation treaties, which often do look at rights to regulate and regulatory space, and they look at competing norms, and treating language is possible in any form. And there are many kinds of treaty provisions that we do see in more recent treaties that are taking account of or concerned with competing norms with respect to climate or environment. But it remains aspirational because it just depends upon what one can negotiate. And country negotiations, international law negotiations are difficult. They're increasingly difficult at the moment because of the world's political state. And I'm personally not so confident that that is the solution. But what I do think actually should be noted is that the sorts of changes that I'm pushing for in terms of the process are actually possible now without any change in treaty language. Even the existing treaties, even the old generation treaties that refer to contractual style international arbitration, those arbitration rules all have in them at the moment sufficient flexibility for tribunals to actually change the way that they do things without being challenged, without undermining natural justice. The UNCITRAL rules are perfectly good. LCIA, ICC, SIAC, AIAC, because they have in them tribunal discretions. They're not tied. They don't actually force a tribunal as a matter of law to a conventional narrow adversarial system. It's just the way that they are operated. So for the second question, I'd hope that countries would be changing their treaties and updating them, but that we're not dependent upon that.
Thank you so very much, Toby. Because another question has just come in the webinar, I'm going to just sneak that in before ending. And this question is a question about claims brought by clean energy investors. So solar, hydro, and wind launching claims against states, cancelling climate change incentives. Now, for this type of claim, in your view, is this also negative to the energy transition? And the example that's given is, say, a claim that will be launched after President Trump has cancelled former President Biden's clean energy incentives. What are your views on that? And then I think we can wrap up.
Yeah, no, I think this is a very, very interesting, potentially positive use of this system. And so I mean, I think without pushing myself into any positions of conflict on pending cases, I think this is an interesting development. And we'll have to see how it pans out.
Thank you so very much for that, Toby. And thank you to everyone who has joined us. And we hope that you will continue to reflect on the insights and the conversations that have been articulated so eloquently by our various panelists. And I think just personally, I really resonate with what Toby has said with respect to changing mindsets, the idea that there must be a progressive and forward-looking approach to this problem. And I hope that everyone in the audience will continue to join Climate Governance Malaysia, AIAC, and the Malaysian Bar as we explore these series of questions in our next two webinars and in subsequent conversations to follow. So with that, I'll draw this webinar to a close. Thank you so very much once again, Toby, Chiew, Dato, Mary, and thank you so much for everyone for taking the time to be with us. Have a very good day.
Thank you very much.
Thank you so much.
Thank you.
Thank you.